Okay,
Okay.
hello, welcome everyone to our webinar Demystifying Trusts with Terry Alexander and our guest speaker Amanda Strausbaugh. She's the Assistant Vice President and Trust Officer at Park National Bank. My name is Eric Danielson. I'm the Communications and Client Services Administrator for AFP. We will be recording this webinar and recording future webinars as well. We will be holding a Q&A session afterwards, and we'll stop any recording before the Q&A. The video for this webinar will be posted on our website within the next few days. So in order to make sure everything runs smoothly, we've muted your microphones and disabled your videos until the end of the presentation. If you do have any questions during the presentation, just feel free to post them in the chat and we will answer them during the Q&A afterwards. If you do end up having any questions after the presentation is finished, and after the Q&A, or you have any suggestions for future webinars, you can just go ahead and shoot us an email or give us a call. So with that being said, I will go ahead and hand things off to Terry and Amanda.
Great. Thanks, Eric. And great to have you, Amanda. I know that this is a tricky area for some people, and just maybe having some general understanding of trust is helpful for many people.
Say thank you. So everyone can see my screen, they can see the slides.
Yeah.
Okay. And I just like to point out my monitor that I have the Zoom on is over here. So when it looks like I'm looking up to God, I'm looking at you guys because the camera is down here.
Okay.
But in general, like they said, my name is Amanda Strausbaugh. I am a trust officer at Park National Bank. And before I became a trust officer, I worked as a private practice attorney for 5 years doing trust and estate administration. So someone has passed away. How do we gather up their assets? How do we get through court if we need to deal with that, or transfer real estate if we need to do that? How do we go through the process of someone has passed away to we are doing something with their belongings? And that's why I really like this area of the law, this area of financial planning. I think that my big point that I make to my clients is I want your family to focus on grieving you and the fact that they have lost you, and not on having to deal with banks and real estate and the court. So how can we make that easier for them to handle? So going to demystifying trusts, the first question is, but really, what is a trust? Because a lot of people will say, well, I know that I have a trustee, or I know I have an executor, or I have some, like, there are a couple of different buckets, and that's the best way I think it is to describe of where you can put your stuff when you pass away that we're going to get into. And trusts are just one of those options. So a trust is just a contract. It is an agreement between three people who are required to create a trust. You have the grantor, which is the person who's making the trust, the trustee, who's the person in charge of that trust, and the beneficiary, so the person who benefits from the assets in the trust. Normally, in the beginning, one person can be doing all three. They are the trustee of their own trust that has the job of taking care of them. And once they pass away, something else will happen. Some people will set up trusts for other people. The grantor will be the grandparent. They are in charge of the trust for their grandchildren until they pass away. And then the trustee might be their kid, or if they don't trust that particular child, a different child, or a bank, or whatever. And I really think that it's easier to kind of have a family idea, like an example, to go through these examples. So I have created Greg the Grantor through state-of-the-art clip art with his family, Greta, who is his wife, and then his 3 children, who we're going to name a little bit later. Now, the other thing that people get confused about when they hear the term of a trust is it revocable? Is it irrevocable? Why is it the so-and-so living irrevocable trust? Why is it the so-and-so living irrevocable trust? The difference between a revocable trust and an irrevocable trust is just that a revocable trust can be changed and an irrevocable trust cannot, to an extent. Asterisks on everything because this is the legal field. But in general, the default trust is a revocable living trust. If you sign a trust that does not say otherwise, Ohio law assumes that it is revocable and amendable. So what does a revocable living trust do? Most of the time, the trustee of that kind of trust has two jobs. One is to take care of you, the grantor, while you are alive. And this is why most of the time you are your own trustee until you're incompetent. And then two, their job is to do something with the assets that you've put in the trust upon your death. And what that something is depends on the terms of the contract. Because, like we said before, a trust is just a contract. It's a document that says, when I pass away, if there's stuff in this trust, this is what I want you to do with it. Just like if you open a bank account, you normally sign a piece of paper that says, hold this money while I am alive. Let me do what I want with it within reason. You can't send money to Cuba. There are laws that prevent you from doing that. But when I die, do something with it. So you've either signed a beneficiary designation form that says to give it to a specific person, or you signed nothing at all, which defaults to it going to your estate.
Mhm.
So the only difference between putting beneficiary designations on all the stuff you own and putting a beneficiary designation to a trust is the trust allows another step of contingencies where you can say, I want this to go to my daughter, but not if she's 2 years old. Or I want this to go to my living children at the time, which is normally language that the bank does not want you to list for a 401k or for a bank account because they don't know who your living children are going to be when you die. And they don't want to be responsible for figuring that out. So to allow planning for contingencies, we're going to go back to our little family of Greg and Greta. So for Greg the grantor, I created some age milestones for him and his family where when he was 22, he graduated from undergrad, got married to Greta, had 2 children pretty quickly in stair steps. We have named them Abby and Betty. And then 10 years later, Charlie came, who is a blessing, and therefore a little bit younger than his other siblings. And having that family unit, when you live an adult life, you accumulate assets that need to go somewhere upon your death. And a lot of people will say in their late 20s, early 30s, even earlier than that, well, I don't have anything to give away, so I don't need to worry about an estate plan. But a lot of those younger people, myself included in this, are worth more dead than alive because you have life insurance through work. You have a 401k that you can't use right now, but it does have a balance. You have equity in your house that you're not doing anything with because you want to continue to live there, but it is something that creates value that would be part of your estate. So even if you only have 5 figures in a bank account, you can still have a 6 or 7 figure estate when you factor in all of that illiquidity that becomes assets that we need to take care of if something were to happen to you. In general, in Ohio, when one spouse dies, the laws have everything default to your other spouse, assuming they're the parent of all your children. There are some asterisks out there that I'm not going to talk about in this presentation. Feel free to reach out if you have any questions about it on if you have kids from other relationships. If you are not in Ohio, one thing that I always find baffling in Pennsylvania, if you pass away without a will, your spouse gets a share, your kids get a share, and your parents get a share, which again is very different from Ohio, where parents only get anything if you have no spouse and no children.
Mhm.
But a lot of the time, the thing that we try to plan around are either the second death of the second spouse or simultaneous deaths. You are in a car accident together. You have some common issue where you both pass away within very quick succession. In that case, all of your assets go one of 3 ways. Either by contract, so a beneficiary designation that you have set with your life insurance company, with the bank, with whomever, by law. So if you don't have a beneficiary designation on your 401k, ERISA kicks in and will say that by default, it will go to your spouse if you're married, if not to your children, or it will go through probate. And now I have said everyone's favorite word of probate, And you're probably wondering, what about my will? I made a will and it says where all my stuff should go.
Mhm.
So a will does not actually do anything to transfer your assets. All a will does is tell the probate court what to do with your stuff. And it normally includes the three important things, which is your executor, so who is the person in charge of moving everything through probate, a guardianship nomination, so if you have minor children who do not have a living other parent, who are you recommending that they go to if you have passed away, and the distribution. Where does the stuff inside of the estate go? So one of the first attorneys I worked with used this analogy, and I'm going to steal it. I actually went to his office this morning, but he was not there, so I couldn't ask permission to do this. But while you are alive, imagine that all the stuff you own is in a basket that you're carrying around. And that basket represents you as a living person with your name, your social security number. When you die, you fall to the ground, the basket spills everything onto the ground, and your assets are just out there waiting to be grabbed. Someone is going to have to pick up those assets and put them where they're supposed to go now that you can't carry that basket. So for Greg and Greta, we have their asset lists that we've made from before. And upon both of their deaths, we have where their stuff is going to go once it's picked up. So their house, their cars, their bank accounts, they did not put beneficiary designations after the spouse. They were like, well, we're not going to die at the same time, so it'll be fine if we don't list anyone after us. So all of those will go to their estates. Now, their 401k and their life insurance policies, they did put contingent beneficiaries on in case the spouse was not around, but they put those beneficiary designations years and years ago before Charlie was born. So we have it set up where those assets are going to Abby and Betty and not Charlie, because they never called HR to tell them that they had a third child that they need to add to that beneficiary designation. That's probably not what they intended, but that's the risk that you have if you don't stay on top of beneficiary designations. If you're not updating them when a child is born, when one of your children passes away, there's no way for the bank or the life insurance company to know that something has changed in your life. And this is probably the biggest point that I make when asking people about their estate plan is, do you want your assets to continue down family lines? So if we have a case where we have Abby, Betty, and Charlie, but Abby passes away first, leaving children, do you want it to still go a third down to Abby's kids? Or are you okay with the chance that Abby's kids don't get anything because you didn't update the beneficiary designations to include those grandkids? So then everything only goes to your living children. That's a risk that you have if you try to keep everything through beneficiary designations and not either have it go through your estate or have it go through a trust. So probate court rules, the big issue with having everything go through the estate, because some people, their response to that question will be, well, if I have it go through my estate, my will says give everything to my descendants per stirpe. That means my grandkids get included, right? Yes, it does, which is good. However, if you have a minor beneficiary, someone under the age of 18, when you pass away, that house cannot be sold without a lawsuit where the court has to have an appraiser appointed by the court, go out to the property and appraise it. It has to sit on the market for at least 90 days. If it's not getting sold for that appraised value, you have to file reports with the court showing exactly how the money was distributed. For cars, same thing. You have to ask the court permission, even if you have an executor, to sell a car, and they have to give an entry that the person who will buy it will take to the BMV. It's just a slower process. And if you have the risk of dealing with minors, it can be a very expensive process. I had a estate that I worked on when I was a practicing attorney where the house was worth about $200,000. There were multiple kids. One kid had predeceased. By the end of it, each grandchild was getting one piece of their dad's share, which was only $18,000, and it cost about $2,000 in attorney fees to transfer that $18,000. So the net benefit to the grandkids was less because we had to go through all the court processes that are designed to protect them, but also can just be expensive if that person who had passed away had trusted someone to take care of it through a trust as opposed to requiring the court intervention. Okay, fine. What if Greg had a trust? So like I said, default trust is a revocable trust. So they would set up the Greg and Greta revocable trust with themselves as trustees, someone as trustee when they pass away, a family member, their attorney, their accountant, a corporate trustee like a bank is an option. And the trust would have two goals: take care of Greg and Greta while they're alive and distribute assets equally to the children upon both of their deaths. And when we go back to a backpack versus a suitcase, the trust can then become the new suitcase to put all of the stuff into until it is safe to distribute it to who it is supposed to go to. So instead of having beneficiary designations that we need to update, we can have the house go to the trust through a transfer on death designation. Same thing with 401ks and cars. 401ks, we have a couple asterisks there because there are a lot of complicated tax laws, unsurprisingly, when it comes to retirement assets. So that's normally something I would want to double check with a financial advisor. It's a little bit easier in quotations, after the Secure Act 2.0, just because the big issue with trying to use a trust beforehand was doing a lifetime stretch. That's not really an option now, but it is still very complicated if you have disabled beneficiaries or if you want to leave some portion of assets directly to a charity. To talk to people before you make that designation.
Yeah,
But same thing, cars,
yeah,
you can
2.0
go ahead.
could make it a little bit more difficult for some of that, for sure.
Yeah, it is both better and worse in different ways, but either way, it is still complicated.
Yeah.
Cars, you can make cars transfer on death to the trust. It requires going to the BMV, which I always joke. I've had people with multi-million-dollar estates or multi-million-dollar trusts that are funded, and then one car that's not in the trust because they didn't want to go to the BMV and pay $20 to put a beneficiary designation. Which again, I don't blame them. Checking savings accounts to the trust, life insurance to the trust. You have everything going to one place, and the benefit of that is you only have to set that designation once. You don't have to fix it every time something changes. You don't have to fix it if your spouse passes away and think, well, I immediately need to go fix everything now. You don't have to think about it when one of your children passes away. You have time to grieve whatever is happening in your life before you make any changes. And then you only have to make that change to the trust, not to every single place where you have assets. So once the grantors die, that is when a trust changes from being revocable to irrevocable. The people who had the power to change the trust are not around. So there's no one to amend it. So it is now irrevocable. And we take everything that they have and put it into the trust, which is just this nice little suitcase. And the other benefit of this is it's easier to deal with these assets inside of the trust. So like another example of Ohio law being silly and confusing. If you have a will that says, give everything to my 3 kids, and you own a house, legally, the second you die, that house theoretically belongs to your children, subject to divestment, which means that they have it, but they do have it. And what's complicated about that is it makes it harder to divide up assets if one kid wants a house and one kid wants all the money, because you still have to either sell the house to one kid or distribute it out to all 3 of them and then deed their interests between them, which a lot of the times, depending on the county, results in more transfer taxes. And it's just more complicated than having the trust be a suitcase where you can say, this house, let's give it straight to Abby. This life insurance policy is the same value as the house. We'll give it to Betty. Everything else is the same value. We'll give that to Charlie. And the other benefit of a trust is the ability to have sub-trusts set up if necessary. So in this case, Abby and Betty are quote unquote adults. They still look like children, but we're going to say they're adults. Charlie's still little. He can't have a bunch of money because he is a baby. So we will give him a subtrust, his own little suitcase, to hold on to what he is owed from his parents' trust to keep there safely until he is old enough to have his own funds. And like I said, this creates all of the flexibility of you have a child who has a disability and can't have assets in their name. A trust is a great way to still provide for them without doing something that's going to jeopardize their benefits. You have a child who has a partner that you do not particularly like or agree with, and you don't want the assets to end up commingling with their marital assets. This is a way to keep those assets out, but still be able to benefit your daughter. There's lots of flexibility with a trust that was a living trust while you were around, but is no longer a living trust now that you're gone. But why does my father-in-law brag about his cool irrevocable trust? So there are lots of different kinds of trusts that you can set up on purpose before you die that are irrevocable when they are created. And people normally do this for a specific reason. The first reason they might do so is for taxes. So right now, the estate tax limitation is 13 point something. That number is supposed to sunset in 2025. So by 2026, it'll go down to 5 million asterisk adjusted for inflation. So it'll probably be around 6 or 7 million at that time. And these kinds of trusts are ways to deal with the fact that you might be subject to estate tax. So like bullet point 1, you have a family farm that's worth $20 million. You're not going to be able to pay the estate tax on that family farm without risking having to cut it up into pieces and sell it. You might get an irrevocable life insurance trust to have life insurance not in your estate that you can use to help pay some of that tax to avoid having to sell the farm. You have a business interest that's growing very quickly, where right now it's only worth like $1 million, but when you die, you think it's going to be worth $20 million. You might want to create some kind of grantor annuity trust where the amount that you're contributing for estate tax purposes is what it's worth now, as opposed to what it will be worth when you actually die. This would be good, again, if you have a startup or something where it's going to grow a lot, but you don't know how quickly it's going to grow. This is a way to still benefit from that asset, but have it get out of your estate for estate purposes. You have a highly appreciated asset. You bought Berkshire Hathaway stock when it was $10 a share. It's now like $1,000 a share. And you know that you want to give money to charity anyway, then you might set up a charitable remainder trust, which allows you to put assets into a trust, get a percentage back to yourself as guaranteed income. And then once you die, whatever is in there goes to charity. And the benefit of that is you can diversify it without any capital gains tax at that time. The last two are spousal related trusts. So a SLAT is a trust where you give your assets to your spouse, but they have control over the assets. A Q-tip is you are giving assets into a trust and your spouse will get all the income. But once your spouse passes away, you have controlled where it's going to go after they are gone. So all of these are just different ways to avoid various taxes. The other reason you might want to make a trust is for asset protection. So you cannot make an asset protection trust if you are already actively being sued. That is fraud. But if you are a young doctor, a young lawyer, a young contractor, you have a big pile of money, and you are afraid of being sued in the future, then you can take some amount of money, get it out of your name, out of your estate, and have that set up to benefit the other people in your life. So if you gather up $3 million and you know, I don't need this $3 million to live, I'm making a bunch of money as an orthopedic surgeon, I'm going to put this in an irrevocable trust for my children now. That way they have this asset available to them. And if I get sued by a medical malpractice claim, I don't own this asset anymore. So it's not subject to that liability. The other big reason that people set up asset protection trusts are Medicaid and nursing home trusts. So you have a situation where you know or are worried that you might need long-term care that will drain your assets. You have a long history of Alzheimer's in your family. You know that memory care in Franklin County right now is about $12,000 a month. And you are worried about losing all of those assets. It is, a lot of people will say, well, I'll just transfer my house to my son now and not have to worry about it. Your son could get sued and then you could still lose the house, versus putting it in an irrevocable trust where it's no longer yours. It's not subject to Medicaid recovery. It's not legally theirs. It's not subject to their creditors, but you have protected it from being a countable asset when you die for Medicaid purposes, for Medicaid payback. Basically, if you use Medicaid while you are alive over the age of 55, even if they're just helping you pay premiums, that is still recoverable. There was actually a Dispatch article that I can't remember when it was, time is fake in this post-COVID world, where someone was saying that their brother's estate owed like $1,200 to Medicaid because it paid for some of his insurance premiums, and he felt like his brother had been lied to because the state said, well, you're not going to have to pay for this, and he didn't while he was alive. His estate had to. So that's why people will use Medicaid trust to get things out of their estate, so it is not subject to recovery when they're dead, and it is not a countable asset while they're alive for Medicaid purposes. So those are the biggest reasons that people would use irrevocable trusts. And again, if you want to set up any of these, this is talk to an attorney, talk to your financial advisors, area to be in, because there might be circumstances where just because it's a good idea for one person to do something, it is not a good idea for you to do something. For example, with a nursing home trust, if all of your assets are after-tax assets, then it might make sense to set up a nursing home trust. If your assets are mostly in a 401k or IRA that's in your social security number, it likely doesn't make sense, because if you try to liquidate those assets, you're going to be subject to taxes on it. It might just make more sense to pay for your care in that circumstances, versus if you have something that's easy to put into an irrevocable trust. So again, all of this is a bunch of asterisks and attorney involved. But in general, the other benefits of a trust are flexibility. So easier management for minors. If you have a minor who inherits anything, you need to have a guardianship of the estate, which means of their money, set up at probate court. And all of that is public record. I can literally go and see how much my uncle spent on his grandchildren's Christmas presents by looking at the docket and seeing what he requested for assets in December. And same thing with privacy. If you have everything in a trust that is not subject to court jurisdiction, you don't have nosy people like me who know how to look at the court docket, looking at the docket and seeing what's in your estate, how much money you had, what creditors you were paying, in the same way that you could if everything went through your will. And then the other thing is the flexibility for distributions, in terms of, while lots of people think that their 22-year-old child is the smartest, best, most responsible person who's ever existed, we are living in a world where if we're using these documents, your child has lost both of you. They are essentially an orphan at 23 years old, and that can be hard to deal with. And do you trust your kid to make the best financial decisions in that circumstance? Probably not. So it's easier to have flexibility of, listen, I'm not going to hand you this $1 million right now, but if you need money for school, you need money for a car, you need money to go on a vacation, all of those are reasons that a trustee can give money to a beneficiary without risking handing a gigantic pile of money to someone who might not be ready for it from an age perspective, and might not be ready for it from a just financial and mental well-being perspective. So that's basically all I had. In summary, trust is a contract, lots of flexibility, because you were saying what the terms of the contract are. And do you need a trust? Maybe, because as I was joking with Terry before this presentation started, if I tell you all of this and you tell me, listen, I know what you just said, but I don't think I need any of this. All this is too complicated. My kids are not going to outlive me. I'm just going to list them as beneficiary and everything, and it'll be fine. That's fine by me, as long as you know what the potential pitfalls of that kind of plan are. I did not include a question slide, but
Oh,
ask me questions. Also, here's a disclaimer.
yeah. And we'll do questions after we stop the recording, just so we've got it kind of separate from the presentation.
Say
Yeah.
sounds good. We're at 12:33, so I feel like I got through things in a reasonable amount of time.
Yeah. Yeah. Great. Thank you, Amanda. Yeah, it's very it is, every situation is unique. No two are the same. It's like a snowflake. So thank you for giving us that big brush overview, because I think it's very helpful. Really do appreciate that.